Okay, great. I have a big mouth. I'm not yelling at you.
We're used to it.
I have been practicing law for a little over 14 years, almost 15 years actually. And recently I started practicing exclusively estate planning. I have an office in Elk Grove, but I also have a satellite office in Folsom off of Iron Point over there by the outlets. My mission is to provide my clients with, you want to come in? Come on in. Yes, come on in.
Sorry.
You're in the right place, that's okay. There's refreshments in the back. My mission is to provide my clients with legal solutions to maintain independence over their health care and financial decisions and to make a smooth transition to their families in the event of death or disability. Now that you know a little bit about myself, I would like to thank Dr. Barber, first of all, for opening up her location to have this seminar. And I would like to also thank you all for coming, taking time out of your busy schedule. And I want to say congratulations. And you might say congratulations for what? For finding a parking space? No. For finding this location? No. Congratulations for taking a step towards making the decisions you need to make for your family, long-term financial solutions. Also, we're going to be talking about a couple of things tonight that most people don't like to speak about, and that's death and taxes. So congratulations again for coming out to hear me talk about death and taxes. I'm excited about presenting this seminar to you tonight. And so I'm going to rely a lot on my notes because I have a lot of information. I want to make sure that I give you everything that you need. Ground rules. First of all, if you have a cell phone, can you please put it on silence? Thank you so much. Now, I have a lot of information, like I said, that I want to give to you. And I want to get you out of here by 10 o'clock. No, I'm just kidding. I'm just kidding. But you know attorneys, they love to talk. So I would like, if you have any questions, can you hold it up here or can you write it down? And I promise you at the end of the seminar, we'll have a period for questions and answers. And I'll try and answer all of your questions. I want you to open your seminar packet. Everybody should have a seminar packet. I just want to go over a few items. First of all, there's this document. Please take a moment to complete the seminar questionnaire. This is a very valuable piece of paper, and you're probably saying, why? Well, this document, if you fill it out and turn it in, it will entitle you to 1 hour free consultation with me. And you may say, well, I'm at the seminar, why do I need a free hour consultation? Well, a seminar such as this is pretty general information. I don't know your specific family needs, your particular assets. I don't know anything about you. So mainly what I'm going to be speaking on tonight are just general estate planning items. Behind that, there's just a little blurb about me, what I do, who I am. Then on the right side, there's a pamphlet, Living Trust. And it's a pretty easy pamphlet, and it has a table that basically tells you what will happen in the event you die without a will, with a living trust. And you know, I recommend that you read it and perhaps share it with your family and friends. Then I put a couple of other articles in the packet that I thought was pretty interesting to read. And I always put the Shrivel. Everybody knows about Terry Shrivel. And that's always an interesting read. And then I put the fee schedule, but behind the fee schedule is the outline, the Estate Planning 101 outline. And if you could just take that out, because this is just a rough draft of the outline, and you can use this to take your notes. Because, you know, I'm a firm believer, if you take notes while you're listening, then the knowledge somehow sinks in, and then maybe you can read it later and apply it to your own lives. Estate Planning 101. What is it, and what do I need to do? Hopefully by the end of this evening, you will be able to answer both of those questions. You will understand what estate planning is and what you need to do. Because estate planning is much more than just a will or a trust. What is estate planning? Tonight's focus is going to be over comprehensive estate planning. Like I said, estate planning is much more than just a will or trust. It's a process that allows and enables you to control and protect your property while you are alive and well, enable someone else to take care of you and your loved ones if and when you can't, give what you want, to whom you want, how you want, when you want, avoid delays, maintain privacy, all at the lowest overall cost to you and those you love. What is usually in an estate? Your cash, your savings, your CDs, your stocks, your bonds, your mutual funds, life insurance, retirement plans, homes, vehicles, boats, planes, investment and rental properties, businesses, jewelry, furniture, tools, antiques, essentially all of your stuff. Now I just want to say something just as an aside. Life insurance, although it is not part of income tax, it's not income tax, but it is included in your gross overall estate value. And we look at the gross overall estate value in order to determine whether or not your estate is in a taxable estate. And right now, taxable estates are any estates over $5.25 million. Who is in my estate? Your family, your friends, your church, your charity, even your pets. Think about your values, your family, your hopes for your children and grandchildren, your legacy, how you want to be remembered by your loved ones, by your children, by your grandchildren. And to also see what you want to happen. Goals of estate planning. If you have a comprehensive estate plan, these should be your goals. Care for yourself during your life. Care for and protect your surviving spouse. Care for, protect adult and minor children. Pass on values and ideals to children and grandchildren. Save money in the long term. Maintain control over the property you have worked hard for. Critical questions. Does your family know what to do, when to do it, how to pay for it, and even if they know all of that, do they have the authority to do so? Do they have the authority to even open your mail? I remember just a short time ago, someone called my office to seek representation, and her dad had died intestate, and he was a widower, and he had 5 kids. He wanted the insurance policy to be equally divided among the 5 kids, and he had retirement, and he also wanted that to be equally divided among the 5 kids. But he had this little house that he only wanted it to go to the daughter who called me. And she was like, you know, I was the responsible one. I'm the one who took care of him, so he wanted me to have the house. And my uncle can attest to that. He knows that that's what my dad wanted. And so then I asked her, I said, well, how is the house titled? And she didn't know, so she went down to the county recorder's office and she got the documentation, and she called me back and said, well, it's still titled in his name, but there is a homestead document here. And I said, okay, well, do you know what a homestead is? And homestead is basically, it protects the homeowner from any lawsuits up to a certain point, your equity. And so he signed that document and he put my name on it, she said, as his child. And she goes, and I signed it and I had it notarized. She goes, well, why did I do that? And I said, well, maybe your dad was misinformed, but the title is who determines, or what determines, who owns that property. And your dad is still in his name, so you have to go to probate court, and the court is going to apply the laws of intestate, and it's going to be split between the 5 of you, even though your dad wanted you to have it. So even if they know what to do, are they authorized, properly authorized to carry out your wishes? Common estate planning mistakes. Now, before we get into specific estate planning techniques, let's talk about some of the common mistakes that I've come across. Doing nothing. How many people can attest to that? Owning property jointly. Designating a beneficiary. Signing a will. Living trust, the bare bones do-it-yourself type. Standalone powers of attorney. Standalone advance directives. Now, the first 3 are pretty passive estate planning tools that a lot of people use. And the will and the powers of attorney and the advance care directives, those work really well with a living trust. Lack of knowledge. This is usually the first reason why people do not plan, is because they've heard of joint living trusts, they've heard of wills, they've heard of joint tenancy, but it's just all garbage to them and they don't understand. So hopefully tonight, if I do my job, you'll understand what estate planning is. This won't be you. Procrastination. With procrastination, we have never heard of procrastination, right? You know, I remember an elderly gentleman in one of my seminars said, procrastination, I know what that is, I had that surgery. So anyway, we all procrastinate. We have a lot of things that we have on our plate. What we're going to eat for breakfast, lunch, and dinner. What are we going to, TV show we're going to watch? What are our kids, are they doing their homework? I mean, we have a lot on our plates. So when I said congratulations earlier, I'm saying congratulations because hopefully you've taken that first step to cross that hurdle of procrastination. Mistake, I'll take care of this tomorrow. Problems, can't predict when disability or death will occur. Health usually gets worse, not better. More likely to become disabled than to die early. Your delay only creates someone else's stress or emergency. Now, I Googled about disability a while back just to get some stats on the disability. And a female who's age 35 has a 135% chance of becoming disabled with a disability lasting more than 90 days than she is to die before 65. And for a male, it's 32% chance. Doing nothing. No plan of any kind in place. Guarantees probate. We're going to talk about probate a little bit later in detail, but I just want you to remember these 4 things about probate. It's public, it's costly, it's time-consuming, and it's court-supervised. It gives all control to state via intestacy laws. No control. Intestacy in California. If you die without a will and you leave a spouse but no children, parents, or siblings, then your spouse will get all of your estate, including all of your separate property. If you die without a will and you leave a spouse and 1 child, no matter how old that child is, the spouse will get 100% of the community property. 50% of the separate property the spouse will keep. But 50% of the separate property will go to the child, no matter how old that child is. They will be entitled to the 50%. And when they turn 18, they can get it all. And the sad part about it is that 50% may not be used to continue to raise the child. If you die without a will and you leave a spouse with no children, but you have parents and siblings, 100% of the community property goes to the spouse with 50% of the separate property. And then 50% will go to the parents if they're alive, and if they're not alive, then 50% of your property will go to your siblings. And this is all dictated by the probate code. If If you die without a will and you leave a spouse and 2 or more children, 100% of the community property will go to the spouse along with 33% of the separate property. And then 66% of the separate property will be divided equally between the kids. If you don't have a spouse but you have children, then your entire estate goes to your children and then it's divided equally. If you don't have spouse, you don't have kids, but you have parents, then they get to divide it equally. It goes on and on. It goes to your cousins eventually. James Dean died at age 29 without a will. His entire estate, including licensing fees, passed to his father, who had abandoned him as a child. Licensing fees generate $1 to $3 million annually, and I just read something. I believe Madonna had to just pay $25,000 to his estate for using him in her MDNA tour. So he's still generating money, and who knows who's getting it at this point. Joint property. Owning property jointly. Very common. We all do it. Married couples, anyone can be joint property. It feels good. We think we're doing the right thing by owning the property jointly. However, there are negatives that we'll discuss later. Jointly held property has its own rules regarding ownership and transfer on death. And it's very important to know those rules in order to understand how it will fit into your estate plan. Problems with joint tenancy. Creates unintended heirs. For example, let's say that you have a will and your will says everything goes to my spouse, and you have a piece of property, it could be your biggest piece of property you own with your brother or business partner, joint tenancy. And when you pass away, your wife won't be entitled to that property that's owned with your brother or your business partner. They get it, and your wife will get whatever is left in your will. Game of survivorship. Last person alive owns all the property. Totally does not avoid probate. Still have to probate property at second death, and that means that when after the first person dies, it goes to the second person, and then when that person dies, who gets that property? Not controlled by wills or trust. Designating beneficiaries. These type of plans, these type of accounts that I'm going to discuss, the common thing about these type of accounts is that we make our planning decisions at the time we open our accounts. They ask, who's our beneficiary? We write down the beneficiary. It could have been 10 or 20 years ago, and that we still have that same beneficiary. So these are the common aspects of these type of accounts. Life insurance, POD accounts, TOD accounts, IRAs, naming the person you want to receive the money in a particular account on your death, commonly referred to as checking the box. It's simple, we don't have to think about it, and these type of accounts here, listed here, are not subject to probate. Problems with beneficiary designation. Subsequent marriage issues, influence on spendthrift children, creditors, predators. Does not protect your spouse. There was this man that had a life insurance policy he bought years ago. And before he died, he divorced and he remarried, but he didn't change the beneficiary on the life insurance policy. Well, guess what? When he died, his ex-wife got all the insurance policies, proceeds. Another man died, and on his insurance policy, it named his brother and another person that his wife never even met. And they received the life insurance policy in spite of the fact that this guy had stopped speaking to his brother for years. And if his estate is a taxable estate, who has to pay the estate taxes on that insurance policy? His spouse, his children, not the brother who he didn't even speak to any longer. Does not protect and care for minor or adult children. Another scenario. Let's say you have a lot of beneficiaries and you want to them to share your certificates of deposit. So you have a certificate of deposit over here with multiple names of beneficiaries. You have one over here with multiple names. So you have several. So what happens if one of the beneficiaries die before you do? What happens to their share? Most likely people want, well, if it's my child, I want my grandchildren to have it. Well, that's not what happens when we name beneficiaries, designate beneficiaries on those type of accounts. If they predecease you, it's like they never existed, and then the remaining beneficiaries will split the pot. So it doesn't protect or care for your minor children. Can cause unfortunate results. Can create unintended beneficiaries. There's no protection against predators or creditors. People, if money is given directly to your beneficiary, if they are getting a divorce, their spouse could get part of it. So it doesn't protect. There's no control. Mistake, I have a will, so my estate plan is in order. Problem, it may be too simple, not accounting for changes in perspectives, circumstances, people, and law. Solution, update your estate plan on a regular basis. You may need to add or delete or change certain provisions. You may prefer a trust-based plan instead of a will-based plan. Wills contain sterile legalese, may not effectively cross state lines, do not become effective until you die. And that's really the worst part about wills. It's like if you're disabled, the will can't just spring into action and someone else can take over and manage your life for you. So that's one of the worst things about wills. Do not protect against a living probate. Like I said, you can't have an advanced healthcare directive in a will or a power of attorney in wills because they won't be followed. It doesn't spring into action until you die. May not protect your children. Again, if your child is young and they receive your benefits, they don't even have to be young actually, just your child receiving their inheritance and they're not ready, or they have a spouse that wants to spend, then your will not protect your children from that. There's also, let me go back, there's also validity problems with wills. Let's say you create your will here in California, but you're going to retire in Nevada. The will, the validity is determined on California laws, and the interpretation and the administration of your will is determined on the state where it's probate, like Nevada. Marilyn Monroe, she died at age 36. Her will left 75% to her acting coach, Lee Strasberg, with wishes to donate to charity. Strasberg later married, and at death in 1982, his estate plus all of Marilyn's licensing and royalty fees went to his widow, a complete stranger to Marilyn, and not a dime to charity. Licensing fees generate over $1 million annually. Mistake, I'm leaving everything to my spouse, so who needs a fancy estate plan? Guarantees probate. Costly administration. Public record. Possibility of multiple probates, and that's if you have property in different states, then you have to open probate in every place where your real property is located. Does not control most property. Types of probate. There's living probate, conservatorship. It occurs either at incapacity or if you're underage. Under 18, all of your assets go into probate. It's judicially overseen, and a lot of people don't realize that. If you become too ill or disable to manage your affairs, then the court will take over. Death probate occurs on death. Process of retitling your assets, and we don't want either one of these probates, not only because the court is intervening, but because there's delays, In death probate here in California, it's estimated between 9 months to years your family could be going through probate. Problems with probate can be expensive: court and attorney's fees, bonds, and document costs. It's estimated that to administer a trust, in a probate, it's between 2 to 8% of your total gross value. And like I said, the gross value is everything that you own, and we're not subtracting any debts. So it's just everything that you own. Time consuming. Special record keeping, court reports, and audits. Like I said before, it can take it can take years. I know a probate that it took the family 4 years to go through. And what if you have a will, and you have in that will you want someone to have a special asset? Well, it has to go through probate before they can retain ownership of it, and that could be a huge disadvantage to your loved one. The proceedings are public. Assets and distributions, provisions of the will or testamentary trust, and what happens when you go to probate? They open a file, and all of your information will go into that file, and it's open to the public, so anybody can view it. I can view it. I don't have to be a beneficiary. I don't have to be your attorney. I don't have to be related to you. I can be your neighbor. I can be a con man. Anybody can review it. And what's in that file, what you had, who you're giving it to, how much it's worth, their names, their addresses, their phone numbers. Do you think that information is pretty important to somebody, a con person? Absolutely. Absolutely. And we all heard that people are camped out on the courtyard steps. Well, they're not just camped out there buying foreclosed homes. They're out there combing through your probate files, looking for potential victims. And if you put your assets into probate, then you're just like putting a bullseye on your family. Lack of control. Sales may require court orders, will contests, and interpretations. Now, let's say that you have an elderly parent that lives with you, and you pass away before your elderly parent. The court can order that house to be sold, and it wouldn't be your wishes. Your wishes would be that you wanted your parent to stay there until the parent passes away. But you can't control that. It's up to the court. Conservatorship, living probate, mental incapacity, minor children. A conservator is appointed to administer your assets. Annual accountings are required. It's expensive. Does not end until death or reaching the age of majority. And like I said before, sometimes the elderly are not able to manage their own financial and business affairs, and so they need help. And if they do not have the proper documentation, the general power of attorney, healthcare power of attorney, then the court will step in and manage their affairs for them. And so the family will have to deal with the conservatorship, and then later on they would have to deal with the probate or go through the probate process. And had the family, planned ahead of time, when the parent was able to make decisions, then that would have saved the family lots of time, money. They wouldn't have to pay a conservator. They wouldn't have to pay a personal representative or an attorney. Probate at death. It's the legal process of paying a decedent's debts and retitling all of that person's individually owned assets into the names of the beneficiaries listed in a will or heirs determined by law. And we went over how the court determines or what it would look like if you died without a will. Death probate. A personal representative is appointed. They notify any potential creditor of the right to file a claim for payment. They also publish notice in the newspaper to any creditors, unknown creditors. They have to do inventories and appraise all assets. They report everything to the court. They seek court permission for everything. Can't do anything without the court saying yes. And it's lengthy, 9 months to years. Costly. Cost of death probate. In California, fees are set by statute. Personal representative and attorney, they're entitled to the same amount. So the amount that the attorney gets, the personal representative gets. The fees, so this is what they get. They get 4% for the first $100,000, 3% for the next $100,000, 2% for the next $800,000, 1% for the amount over $900,000, and for amounts over $25 million, there's special rules. Then there's costs, there's like miscellaneous costs, appraisal fees, filing fees, publication fees, miscellaneous expenses. And it's estimated that these expenses are about 1% of your estate. So the average cost to administer an estate through probate is 2 to 8% of the gross value. And you may say, Teresa, what are you talking about, the gross value? Okay. Let's say we have a family that they only have a house, they don't have any debt, and the house is worth $550,000. So their gross estate is $550,000. So the estimated cost of probate is $33,000. And that's the personal representative fees, the attorney fees, and the miscellaneous fees. So it's $33,000. So the effective rate is 6%. Now we have another family. They have the same house, but they have debt. Again, their gross estate is $550,000, but they owe $500,000. I mean, $500,000. So their net estate is $50,000. And after we take the attorney's fees, the personal representative fees, and that miscellaneous 1% fees, their estimated cost is still $33,000, but it's 66% of the net of what they were going to leave for their loved ones. So we're just looking at one asset is between 6 and 66% just to go through the probate process. It can be very expensive, and probate is not just for the wealthy. If you own a house and have a checking account or a bank account, you're going to be going through probate. How to avoid living and death probate. Use a revocable living trust. Use a power of attorney that's effective when incapacity is determined. Provide personal care guidelines. Have and register health care documents. Use standby guardianship and medical consents for minor children. What is a living trust? It's similar to a will. It's a will substitute. It says what you have, and it says who you want it to go to. So what's the difference? How a trust works. One of the main differences between a will and a trust is a second step occurs that doesn't occur with a will, can't occur with a will. And what the second step is, it transfers your assets out of your name and transfers it into the name of the trust. You know, when I set up a trust, the people, my clients are the trust makers are the grantors and the original trustors. And they're also the original trustees or the managers of the trust. And they're also the beneficiaries, so they get to use the assets that's in the trust, and it's for them, it's for their benefit. So what's the difference? Well, once the trust is signed, then we retitle the assets into the name of the trust. So that house that says John and Mary joint tenants is going to be retitled and redeeded into John and Mary trustees of the John and Mary Trust. So John and Mary now have a fancy new name called trustees. So what does that mean? During your lifetime, it's business as usual. You're in control, and your living trust is amendable. You can change it, and it's revocable. Or if you're married, at least half of it is revocable, if not all of it. It's merely a standby device. So you can open and close accounts. You can buy, sell stock, real estate. The taxes that you pay, your real estate taxes that you pay, will remain the same. You'll still get that Proposition 13 bill. You still file your income tax the same way you do it right now in your name. Everything stays the same, and it's just merely a standby device. So here's a trust right here. It's just sitting there. Your trust would just sit there, sit on a shelf or in a closet or in a safe. Just sit there silently, invisible, but it contains all your stuff. And you do everything, you go through your life like you've been doing. But if you or your spouse becomes disabled, or you or your spouse becomes or dies, the trust springs into action without having to go to court. And that's the main thing. You don't have to go to court. It's a smooth transition. Living trust. Various types commonly promoted. Bare bones trust. Fully funded trust with powers of attorney, healthcare directives, and other important documents. And this is the more comprehensive one. And funding, like I said before, funding is just retitling the assets or into the trust name, or if you have beneficiary accounts, renaming the beneficiary to the name of the trust. Bare bones living trust. Out of the box software you buy, do it yourself. Traveling salesman, one size fit all, no personalization, assembly line process. And if all you want to avoid is probate, then this trust may work for you if it's properly funded and it's written properly. This will work. But if you want one that represents who you are, your values, your goals, your desires for your family, you want it to carry on your legacy, then this may not work for you. Bare bones living trust. May not comply with state law. No personalized planning. Someone else decides important matters for you. Cookie cutter design. Often not funded or improperly funded. Non-trust assets will require probate. May not fully utilize all tax breaks. Improper property ownership may prevent implementation of the trust plan. And if it's not funded, if your property isn't in the name of the trust, your family will still have to go through probate. I know this family that came in, and on the outside the trust looked really good, but after reading it, they didn't fund it properly. And so they ended up having to open probate, not only here, but they also had to open up in Nevada, and the Nevada one was litigated. And half the family, half the parents, spent a few extra $100 to plan it properly. It would have saved their kids time and expense, and also they wouldn't have had to go through probate. Fully funded living trust. It's like a packed suitcase for a trip. I always tell my clients that that the trust that I make, it's like how when you go on a trip overnight, no matter how hot it is outside, how you always pack a sweater just in case? Well, the trusts that I create are just in case. They have a lot of just in case language. And the reason being is because I don't have a crystal ball. So I don't know what their life is going to be like when they pass away. I don't know what their assets are going to be like. I don't know if they're going to be in a taxable estate. I don't know what their family situation is. I don't know. So I put in little sweaters for just in case. It's filled with items that may or may not be needed. It holds property for ease of transfer to heirs. Ability to put in and take out property as needed. It's managed by a trustee. Remember I said you're the original trustee, the first manager. Can be an individual, set of individuals, bank, or corporate trustee of your choosing. Trustees are replaced as necessary due to death, change in circumstances. Again, those are the little sweaters just in case. You can name your kids as co-trustees. I see that a lot. Or if someone totally independent, an attorney friend or an accountant that can manage the fund. So a trustee is someone that you will entrust the rest of your estate to when you're gone. Fully funded trust ensures long-term control over assets. You set the rules of inheritance. You set the rules for success that successor trustees must follow. You set the guidelines for care on disability. Can plan for many different situations, children with different needs, pets, remarriage of spouse, charitable contributions, special religious desires. Easily amendable. Maximizes use of deductions and exemptions for tax purposes. Now, if you want what we talked about, the protections, the family protections that we talked about, then you do want a fully funded living trust. And the tax benefits, that's just an added benefit. Why a joint living trust is better than, why a living trust is better than a joint tenancy or a will. Now I'm going to discuss in detail a little bit later about living trust, but I want to just go over why a living trust is better than the more commonly used estate planning tools. Now, many people favor the joint tenancy because it's and a will. They favor both of them because they're easy. Joint tenancy, you just open that account and sign your name and you forget about it. Or when you sign your deed, your property deed, you sign it and you forget about it. And when the first joint tenant passes away, it goes to the second one with probably very little paperwork, if any. And a will is simple too. I mean, it may cost $1,000 or so, and you sign it and you put it in your drawer and you don't think about it until you pass away. So a will and joint tenancy, they're both cheap and easy. But cheap and easy should never be two words that we use for any important major things in our lives. And estate planning is a major thing in your life. And so cheap and easy may be a big mistake. Now, distributions to the right people, important whether you're married or not. And this, if I took a poll of this room, this is one of the most important reasons people say that they want to make sure that their distributions go to the right people. Now, what's surprising is that joint tenancy does not guarantee that it actually goes to the right people. And I'll give you a few examples. Okay, so we have a mom here, and she has 3 kids, and she has a will. And her will says that if she dies, if one of her kids predeceases her, then it'll go down to the grandchildren of the predeceased child. And that's usually how it goes, and it's understandably because that grandchild or those grandchildren probably need it more than the two older adults that are left. So that's the will. And then we have a mother over here. She has joint tenancy, and she has 3 kids, and she put her kids' names on her accounts and on her deed, but one of her kids predeceased her. Do you think that kid's property would pass down to their kids, to her grandkids? No, it will go to the 2 surviving joint tenancies. So joint tenancy does not always guarantee that the right people will get the distributions that you want. Now, this is a very, very, very common situation. Dad dies, and so daughter comes and she moves in with mom to take care of mom. And to make it simple and easy for mom, she puts daughter's name on the her accounts and also on the deed, just in case something happens. And she says to daughter, make sure that when I die, you split it evenly with your brothers and sisters, okay? And so, is daughter legally obligated to share with her brothers and sisters when mom passes away? It's not. So, again, distributions to the right children. Or to the right people, I'm sorry. Now, we have other situations where there's a joint tenant and one joint tenant dies, and of course it's the second joint tenant will get the property, but what happens when the second joint tenant dies? Who gets it? So joint tenancy doesn't guarantee that the right people will get it. Now you may say that, well, a will, I can say, okay, if my child predeceased me, then I want it to go to their children, right? You can do that with a will. But where there's a will, there's a probate. Exactly. Now with a living trust, you can avoid probate and make sure that the distribution goes to the right people. This is the second important item. May defer distribution until you feel appropriate. The cash you will leave people is more cash than you have right now. The cash that you leave people is more cash than you have right now. And you say, how is that possible? Well, some minds greater than mine took a survey and found that 95% of your family will sell the family home when you pass away. That's a few $100,000 right there, right? And then when the life insurance policy matures when you die, that's another few thousand or some $1 million policies. And then that retirement account that you've been rolling over and over and over and over, they get that. And then we're talking cash accounts, stocks, bonds. It goes on and on and on. The cash that you will leave is more cash than you have. And probably more than they have. And do you think that they are capable to handle a whole bunch of cash all at once? Probably not. And so the will can't prevent that from happening. I mean, the will can defer distribution. I'm sorry, the will can defer distribution, but again, where there's a will, there's a probate. Exactly. And then with joint tenancy, you can't delay. So they get it right when you pass away. The joint tenants do. Do you know, I found this pretty interesting. How long does it take for a person to get their inheritance check and get to a luxury car dealership? 72 hours on average. So living trust can avoid all that. It could avoid the probate, and it can defer the distributions until it's appropriate. May avoid court interference, delays, expenses, and publicity. Now, we know that with the joint tenant, again, if you pass away, the second joint tenant gets it, no problem. But what happens if you become too ill or disabled to handle your affairs? Now, joint tenancy, on some accounts, some bank accounts, the joint tenant could go and sign their name and handle your affairs, but there's other items that the joint tenant can't take care of, can't manage on your own. They can't go sign a deed, and they can't do other business, so they would have to go to probate to get a conservatorship over you. So joint tenancy does not avoid, court. And then, of course, we all know that a will does not take place, does not become effective until you die. So again, if you became too ill or disabled, your family would have to go to court. And a will is just basically a ticket to probate court. A will just basically says to the judge, hey, Your Honor, this is what I have, and this is who I want to have it. But trust can avoid both probate and living probate and death probate. May reduce or eliminate estate taxes. And right now, we didn't go off the fiscal cliff, and so they did extend the estate taxes.